for today's session. I am of counsel for a law firm in the UAE called Global Advocacy and Legal Counsel, and a big fan of TIAC arbitration. I serve as an arbitrator and also have a lot of experience as an advocate in arbitration. We have a great panel today covering some very difficult issues. It's, for those of you who've joined these sessions this week for Uzbekistan Arbitration Week, and they've been amazing, the sessions, and I've certainly learned a lot. One of the things about this session on financial services issues and arbitrators and the need for having more arbitrators in this space, financial services is getting highly complex. Now we've had other sessions this week where we looked at construction arbitration, and there are a host of issues associated with construction arbitration, and the issues discussed were diverse and useful, and we all learn things, and there's a game plan for moving forward. We discussed FIDIC, but there's a narrow universe of issues and possible solutions for construction arbitrations. Likewise, when we address sports arbitration. Today, when we look at financial services, it's in some sense all over the map, and who knows where financial services are going to be in 5 years, but we're going to try to get a handle on them today and try to determine, is there a need for more arbitrators in this space? I suspect we're going to conclude the answer is yes, but let's see. And what is the nature of what arbitrators need to know and learn if we are going to be in this space more and more? And if the answer is yes, and for those of us who don't have the requisite financial experience, how do we get it? And what is the extent of what we need? 8 issues or sub-issues, among others, that I would hope our august panel will address. What do we mean by financial services? What are the new hot financial services and products? What particular kinds of financial disputes are being litigated or arbitrated nowadays? Is there a trend for financial services disputes? For the disputes to be resolved via arbitration as opposed to litigation? The whole issue of enforcement, arbitration versus litigation, that's an ongoing discussion. Should arbitrator tribunals be determining disputes with 3 arbitrators, at least one of whom has background in finance, or is that not necessary? Or do we need all 3? So these are questions I hope our panel will touch on and address. And finally, if we can have some guidance for the lawyers in the audience, young and old, aspiring and experienced, what is it that we need to do and learn? How do we do it? And how long is it going to take? So these are sort of the issues that I think are important. And of course, our panel will have something to say about that. Our panelists include Mr. Igor Gorchakov from Allen & Overy, He's a partner there in the Moscow office. Nargis Duzmatova, she's the managing director of FinExtra Group. Dr. Hussam Al-Tahuni, legal consultant to the UAE Ministry of Finance. And Dr. Tahuni, by the way, was the one who encouraged TIAC to address this subject. So I'm thankful to you, Doctor, for that. Great subject. Difficult, but needs to be discussed. Mr. Erkin Turabov, head of legal at JSC MBU. That's the largest commercial bank in Uzbekistan. And then we have Dr. Yui Wistup, who has a PhD in mathematics, and engineer Jamal Chaykuni, who's our civil engineer and also very well versed in all of the different arbitration centers and some educational programs. So we'll be looking forward to hearing from our experts in mathematics and civil engineering and see what say you. So without further ado, Igor, if you don't mind, I'm going to start with you. And let me just take one more minute and read a paragraph from your illustrious CV, which is quite impressive indeed. You are out of the Moscow office, and let's see here.
Yeah, John, sorry, I'm afraid we have lost you.
Okay, how about now? Can you see?
Yeah, absolutely.
Okay.
That's much better.
Great. So Igor is an advocate and partner in banking and dispute resolution practice at Allen & Overy in Russia. He is an experienced and versatile Russian lawyer with over 25 years of experience, specializing in banking and dispute resolution, including domestic and cross-border litigation and arbitration. He is an associate member of the Chartered Institute of Arbitrators and a member of the Moscow Bar Association. Igor is recognized as a leading practitioner by major legal directories such as the Legal 500 Chambers, and let's see, and there's a bunch of other stuff in your CV. You're clearly highly qualified for this. Just one quote at the end, which I think is important, from your clients, who praised Igor for, quote, communication skills and ability to handle quite complex negotiations. Igor, the floor is yours.
Yes, thank you very much, John, for such a presentation. I just say probably a couple more words about myself, that I'm taking for that particular discussion a unique position, because as John said, I'm on the one hand a banking lawyer, i.e. I'm drafting and negotiating various finance transactions. And on the other hand, I'm also a disputes lawyer and the head of Moscow Dispute Resolution Department. So I deal with these transactions where they end up in the court or international arbitration. So I have a chance to see how things are evolving from the start to finish. What I wanted to start with now is to show you some statistics just to see where we are in terms of resolving financial disputes by way of arbitration as opposed to resolving them by way of litigation. So let me share the screen. Can you see them now?
Yes, we can.
Yes. So, well, first of all, I would like to draw your attention to what the perception of people, according to, or of financial markets participants, according to very, I would say, authoritative surveys done by Queen Mary University. Well, the first survey that I referred to was done in the year 2013, and it says that probably only 23% of responded said they would opt for choosing arbitration for resolution of their financial disputes other than litigation. And if you compare this figure with the 52% of responses who said for all other disputes generally, that they would prefer an international arbitration, you would see that the figure for financial disputes is really very, very small compared to that. So much fewer players would be prepared to go, that operate in financial markets would be prepared to go to an arbitration than the players generally who select the dispute resolution venue for their contracts. However, if you will take a look at the result of the survey, the same Queen Mary University done in 2018, i.e. 5 years later, you would see that the figure would be slightly different. And there, already 56% of respondents from banking and finance area said that they would likely choose international arbitration for cross-border financial dispute. A very pleasant trend, isn't it? And when we take a look at what happens in practice and see some statistics for financial disputes in various institutions, we also see that this trend is supported by that. A good example of this is LCIA, where the number of financial disputes submitted to arbitration, to LCA arbitration, is growing every year. So I've given you here a bit of a trend from 24% in 2017 to 29 in 2018 and 32 in 2019. That means that a third of the disputes started in LCIA are the disputes arising from finance transactions. Well, other institutions show a bit more modest figures, but I think this is mostly due to the fact that LCIA is traditionally, I mean, London is a traditional place for resolving financial disputes generally. But still, we see that there is, if we look at SEAC, for example, figures, well, 10% of all the disputes being financial disputes resolved by SEAC in 2018, it's not that bad for a start. So, so the question is why why arbitration could be more beneficial for resolving financial disputes, and what kept parties, I mean, mainly financial institutions such as banks, not to choose the arbitration so widely for their disputes so far. Well, as we know, arbitration, as compared to litigation, has a number of advantages that I think is applicable to finance area as well. But unfortunately, these advantages were kind of erroneously misperceived by banks for quite a long time. What I see that now situation is changing. Well, as an example, in terms of advantages of arbitration, I would say that, well, first of all, it's the neutrality of the arbitration. When you choose an arbitration, you are as opposed to local courts, you get a chance of getting a more neutral tribunal, not tied to any party of the transaction, to any country that will review the case. The arbitration is more flexible. What arbitration offers to the parties, which you don't find in litigation, is confidentiality, which is quite important for a number of financial disputes. Also, the arbitration awards are final and binding, so there are no various stages of appeals, and you're more kind of you're not, more kind of now predictable in terms of when you get the result. And finally, when we speak about the enforceability of the arbitration awards versus the judgments of the court, it's much easier to enforce arbitration awards in other countries than most of the court judgments. So we see all sorts of advantages, but why then banks were so reluctant to go to an arbitration? As I said, there were a number of misperceptions, and I think erroneous perceptions of arbitration. Well, first of all, and that's, I think, the issue that we will be discussing today, the banks thought, I mean, for major disputes, the banks were mainly looking for major disputes at courts in New York and England, in London, and they thought that the judges there are more experienced in resolving serious financial disputes than arbitrators generally. And also in terms of neutrality, there was a perception that London and New York are very creditor-friendly jurisdictions, and therefore, in that sense, arbitration has no advantage over litigation in these courts. Also, what was quite important for banks, and is still important, that the availability of a predictable procedure, and also in particular, such things as interim measures and summary judgments, because not all financial disputes are very complex. There's a a big chunk of these disputes which are quite straightforward. I mean, for example, in the situation of a bilateral loan where a lender lent the money and the borrower is just not repaying, there's not much to argue about, and the lender is interested to get the judgment as soon as possible, and the summary procedure available at the courts is very helpful to it, and the lender naturally doesn't want to spend years in arbitration just to resolve this pretty straightforward dispute. On the other hand, there are many financial products which are overly complex and based on certain standard documentation, such as syndicated loans that are based on LMA documents, or derivative transactions based on UzAW. And there, the concern of the banks is absolutely different. So they would be more comfortable to rely on the precedents built by the courts and the knowledge that the judges that specialize in financial disputes have, rather than on arbitration or arbitrators where they are not sure that they can pick an arbitrator with the relevant experience who would be able to interpret and apply correctly those very complex documents. And if you look at a standard LMA syndicated loan document, in particular, if you look at its dispute resolution clause, it says English courts, full stop. And that was a story for UzAW documentation as well, because the standard documents for 1991 and 2002, when the new version of it was developed, also said only about English courts or New York courts. But what recently changed that now UzAW has an arbitration guide which offers over 11 versions of various arbitration clauses for various arbitration institutions. So we see that the situation there is changing, and the banks are prepared to shift towards arbitration, even with such complex disputes as disputes over derivative transactions. And I think here we came to the core of our discussion today, is that one of the concerns that the banks have when looking at arbitration, with all the merits, and also I forgot to mention the enforceability of arbitration, because, for example, when we speak about judgments of English courts, if you to enforce them against the counterparty in emerging markets, well, such as Russia, for example, in principle you can do it, but it will be a nightmare when you start that. It will be much more difficult than enforcing an international arbitral award due to the availability of New York Convention and a very extensive practice of enforcing these awards. So there are a number of merits that arbitration is offering now, and we see how the arbitration rules are evolving, and many institutions are offering urgent measures, are offering what could be called an analog of summary judgment. Well, as an example, I should mention clause 29 of SIAC rules, for example, who can who allows arbitrators to get an early relief of the defense or the claim if the defense or claim is without legal merits. Well, which is great, which is what the banks, exactly what the banks need for pretty straightforward disputes from bilateral loans that I mentioned. But the main concern that is still there with the banks and financial institutions is whether they will be able to get a sophisticated and experienced enough arbitration tribunal to resolve their complex dispute. And in various areas, as I mentioned, not only derivatives, but it also concerns bonds, insurance, etc., other disputes.
So Igor, is it fair to say that it's so if the banks are willing and the trend seems to be, okay, arbitration makes sense in these kinds of disputes, is the burden shifting to our community to kind of do what we're trying to do today, which is encourage more of our arbitrators and aspiring arbitrators to step up? I mean, is the ball in our court?
Yes, I think that is exactly the case. That is exactly the case.
Very good. Well, that's a good segue. And please, stand by for other questions. For Nargis from the FinExtra group to weigh in with some of these complex financial instruments and trying to make sense of all of these, whether we call them securities, investments. I mean, just yesterday, Coinbase is now the subject of an SEC investigation as to whether one of the instruments that they're issuing constitutes a security, which of course would mean the SEC has jurisdiction. So, everywhere you turn, and this is why I love this issue, and this in terms of its difficulty, and it's constantly evolving, constantly changing. We're having a hard time keeping up, but we have to. And so I know, Nargis, this is one area that you are, staying on top of. So Nargis is the managing director of Finextra Group, which happens to be an exclusive partner of the world's largest fintech company, Finastra. Love that name. Nargis has over 15 years of experience in the fintech industry, where she worked as a consultant for new business development, banking software sales, project management in the banking sector, as well as partner management with global fintech providers. Today, her company is actively working on creating a fintech ecosystem in Uzbekistan in order to develop innovations and improve regulatory framework for such innovations. Nargis graduated from Middlesex University Business School in London, Harvard Business School, Massachusetts, in Harvard Business School, of course, we know in Massachusetts, the executive education program for entrepreneurship, as well as Oxford University in the FinTech program. Your credentials are quite impressive. Nargis, the floor is yours.
Thank you very much, John. Thank you. And hello, everybody. Thanks for the introduction. And let me thank you for such, for organizing such a meaningful event, especially for the fintech players such as us, let's put it that way. I can see that we have a different players here from the different angles. I see commercial banks from Uzbekistan. I see, mediators. I see arbitrators, lawyers, and so on. And I think that's a very good start to start engaging on some particular issues. But before I talk about the issues, let me kind of give you a little bit of a glimpse in terms of the financial sector in Uzbekistan predominantly. So you can probably, that kind of will give some clarity on where we have these disputes coming from. And the readiness of our industry overall, how this is, in terms of where is it right now in terms of the development, okay? So somehow it's not moving. Oh, okay. So I want to start by bringing some of the figures that has been communicated by KPMG, and these are the studies that have been performed last year during the COVID time. So we have been assessed as a country in Uzbekistan compared to these other CIS countries, the neighboring countries, such as Tajikistan, Kazakhstan, Kyrgyzstan, and all the other STAN countries. So as you can see, the fintech development itself is pretty basic, right? So I should say we still have about let's say less than 50 companies that are doing any kind of a fintech. Predominantly, most of that is connected to the payment system or the processing systems. So exclusively companies that are just focusing on the fintech banking software or the financial services software, there are just a few of them. Let's put it even about 12 or 15. So the level of digitalization is still pretty low despite all the COVID restrictions. And as you can see, the Global Innovation Index, we're still pretty, pretty far from the standards, still 93rd place. And ease of doing business is 69th place. So what it means in the figures is that working with some international biggest brands, the international companies are still very skeptical of presenting themselves or presenting the brand here in Uzbekistan directly. Okay, so it causes some of the issues of frustrations in terms of signing the contracts directly, and because there are some of the aspects that I want to probably share at the later stage in a different, in the later slides. So moving forward in terms of capturing the trends of Uzbekistan, we see some of the booms, right, of new technology and disruptive technology, as you would say. We have Islamic banking, which is on the verge for the past year. And banks are very much adopting this trend right now. We have omni-channel solution. We have been talking about those innovations for the past 5 years, but the real innovation started with all the COVID stuff, when the COVID started to kick in, because there is a need for the corporate and retail banking to adopt such a new technology in order to cater the clients. Also, we see the business process re-engineering needs all sorts of systems or the technology that will help banking financial services institutions to give loans, to manage those loans, to manage the credits, and so on. We see risk management adoption, which is very good thing, as we can understand that obviously they're managing the credit, market, operational risk, and more importantly, it has become very urgent trend or adoption, because we see quite a lot of investors interested in our country, and we see the risk management is always at the heart of any business, whether it's banking, financial services, or even IT company. So obviously we see more of the requests, or the trends moving towards the artificial intelligence. More requests are coming from the public sector, and also the blockchain adoption. We know that all these technologies are very quick and fast moving, and certain regulation needs to be adopted, or certain legal expertise needs to be covered subsequently. So now moving forward towards the some of the issues that we face or witnessed for the past couple of years, working with some biggest brands, we see that obviously I have mentioned that in the past, but local contracts are usually done with mediators such as our companies. So more international companies are not so keen, as I said, to present themselves. They are not much in a rush to position themselves as a direct contract holder, because there's still some of the aspects such as, and Igor has mentioned, obviously, the disputes in the court of the UK, which most of the local banking financial services are not pretty, they are not in the rush to sign such a contracts, because they don't know whether they will be capable of managing those disputes somewhere outside of the country. Also, these risks of market risk, currency risks, the operational risk, moreover, reputational risk. And so needless to say, in our country, with our specific region, people are changing constantly. So even if you sign a contract with one company, with one team, the project will be happening with a totally different team. And when the time of evaluation of the project, it will be with, let's say, completely independent team in the banks or financial services. So there is a lack of change management, although we are as a country or as a company working towards adopting change management and creating some kind of methodology. So there's still a lack of knowledge of how to manage those transformation. And I'm talking it from the perspective of financial technology. So I do have a lot of stress on the technology adoption as such. So regulation is still, I'm not going to say far from perfect, but the area where we are working as a fintech, and since we are moving so quickly at the race, I don't know, it's much quicker than adoption of the regulation. So a lot of points are actually not even covered in the current regulation as such. And there is no, I would say there is no reason for us to put any dispute, and there is no basis for us to link it to any kind of regulation. Also, the human capital, which is, I would say, is at the heart of any kind of dispute that is currently listed here. So we don't have people, we haven't been, the country overall, or the banking financial services in Uzbekistan, haven't been facing such a big transformations in the banking, right? So we haven't adopted fintechs before, and the term of a financial technology as it is only appeared about 2 years ago, right? So obviously we see the issues in the human capital, and all these points or the pillars actually causes the rising legal disputes, right? Because there is a lack of knowledge, there is a lack of understanding how the technology should perform and what the outcome should be. So in terms of some of the kind of most happen disputes and that we see and our partners see in this region is obviously through the contracts. We're talking about different type of contracts which covers the licensing, the SLA, the service agreement, the outsourcing, and so on. And the list is not the full list. It's, more points are actually adding up because we are embracing new technologies, and that list will be increasing, let's put it that way. So my message today, as maybe the only one here on behalf of a fintech, my message here is the fact that we as a local company, we are becoming at the spotlight of the most risks because we work with international companies from one side, but doing business with local banks and financial services industry. So what we do, we can't mirror all those risks, unfortunately. So we are the one who is at the heart of these disputes. So what I want to say is that obviously we are, when we face such an issue or the conflict, we are not in a rush to go to the courts. First of all, because courts do not have the necessary expertise. That's one thing. And second thing, we don't want to wind up in the very long stages of appeals, right? So, and third one, which is very important for us and our partners, is a reputational risk. Because somehow in our country, it's perceived that if you start doing if you start initiating the law dispute, then it means, you're not a very good company to work with. Unfortunately, this is the truth. And I have to talk about that because this is not only our company that's going through these issues, but also most of the international and local IT companies are facing the same thing. So what I want to probably, I really want to make a call for a massive need for the arbitrators, especially in the financial technology as a new trend that is rising right now in Uzbekistan. And because of the recent development in the reform, IT has becoming one of the key pillars for the economic development in our country. So I should say that obviously, what we need to do is to have a single platform where we will have where we can really preserve the business reputation and can really have that particular service as from the legal side, from the technology side, and from technical expertise that we can provide at a single kind of, in a single procedure. So I would pass it to you, John. Any questions?
Yes, I do. And I'm sure there'll be some audience question from the audience, but I would say that I get your point regarding you don't want to be seen in your country as initiating litigation or arbitration. Is one way of avoiding this, I guess, is there two ways. Number one, having clearer contracts, if you will, between the parties. Perhaps that's something that can be worked on. But I would say more importantly, because you're suggesting, and I think we've all seen it, no matter how good your contract is, people may misunderstand or not understand some of the elements of the new technologies. Therefore, I wonder whether or not mediation, some sort of mediation, makes sense as opposed to litigation, and how would that be construed in your country? It's not going to arbitration, it's not going to court, it's still taking a pause and having a neutral come in, a mediator, to sort of sort it out. Would that be accepted?
It probably will, but we do have different approach in the financing itself in terms of how the contracts are actually structured. So we actually use that Russian standard where let's say in Europe or the UK, where I've been working for a number of years, we have a totally different approach in terms of understanding what the contract is all about. Where in developed countries, contract is everything. It's a book where you are abiding the clauses that you should stick to, right? Any kind of a changes in the contract are usually perceived as a holy book, let's put it that way, right? This is an agreement which is carved in stone. Whereas here in Uzbekistan, a slightly different way. So contract is just the beginning of your relationship. Okay, the clauses are something that can be stick to or can be not stick to. A lot of communication is happening on a verbal level. So that's another thing. That's probably the difference between how we do the business here and how the developed countries do. So furthermore, after you, let's say, submit your when you deliver your service or the product, there is another point, which is the act of acceptance. And I'm sure Russia also follows the same standards. Whereas this is an opportunity for the buyer or the banking or bank financial services to assess your work, which is very much a logical way. But this is when the fun starts, right? So this is when we have lack of understanding, lack of knowledge, lack of how it's supposed to be. So basically, I want to order the Ferrari, but I haven't seen this Ferrari, right? So tomorrow I will say, well, this is not the Ferrari, and this is when the fun really starts. And this is where this dispute happening. So this is, I'm not sure whether all the remedies can be applicable in our country. So this is mostly because the accountancy standards are slightly different, because the acceptance of work is different. And there are a lot of points where the supplier actually has to prove himself, saying that and this is all built on trust and the relationship are falling when people are leaving the organization. And this is one of the biggest risks and one of the biggest issues that we have, because business is all about people, unfortunately. And this trust is built with people. And when someone is leaving or, not continuing this relationship, this is all falling into pieces. And this is where we are looking for the disputes.
Yes, indeed. Well, that's a good point. Well, thank you for that, Nargis. I think I'd like to carry your point, so many good points, but one that stands in my mind is the one you make about contracts in Uzbekistan. They're often considered this just the start of the relationship and not really looked at again until there's a dispute. I remember the UAE was like that a long time ago, and it'll be interesting, and I'm going to ask Dr. Talhouni to step up next to get his perspective from the UAE on all these issues, and given his extensive experience in the UAE on so many different levels. Dr. Talhouni is, as I mentioned, the legal consultant to the Minister of Finance in the United Arab Emirates. He's done so much over the years. He also happens to be a personal friend. His job responsibilities include providing legal consultation on various matters, including drafting federal legislation and ministerial orders. And I've been in Doctor's company when he's in the middle of these things, and it's quite a big responsibility. Areas he's covered are bankruptcy, the insolvency of national persons, securing interest with movable property. These are all laws that he's worked on and helped draft. Finance leasing, trusts, factoring law, fintech draft law. So it'll be interesting to hear Doctor's perspective on where the UAE is on fintech. And because we just heard from Nargis where Uzbekistan is. And Doctor's also worked on the data protection and Financial Services draft law. And that I'm sure that might have been an impetus for him to suggest that we need to address this issue. Tax laws, relevant bilateral international treaties. Doctor obtained his PhD degree in international commercial arbitration from Edinburgh University. This educational background has provided him with the needed knowledge and skills to be able to work under both civil and common law systems, in addition to Sharia law and Lex Mercatoria. He has lectured in a variety of well-established universities in Jordan and the United Arab Emirates. He is an author of several publications on various legal topics, including arbitration, private international law, commercial arbitration, and a PhD thesis on, quote, the effect of public policy on the enforcement of foreign arbitral awards. He's the secretary of the Financial Reorganization Committee since 2018, and he was appointed by ministerial decision in 2018. Quite a responsible position, and he was, again, I know from personal experience how involved he was and continues to be in the bankruptcy and reorganization laws in the United Arab Emirates. He's a well-known name in the field of legal services, particularly in international commercial arbitration. Among his many incredible achievements, he served as the inaugural director of the Dubai International Arbitration Center, starting in 2003. I can go on and on. Doctor is the co-founder of the Arab and International Arbitration Network, but time is an issue. Doctor, the floor is yours.
Thank you, John. I should add also proudly that I am a member of the supervisory board of the TIAC. So I also...
Yes. Thank you. Yes.
Well, financial services came to my life from my practice as drafting various laws relating to financial services. And I noticed how difficult it is, how complex the issues in financial services, and how the variety that comes into play when you consider laws of the central banks. And you will find sections that defines what are the financial services in various countries. In the UAE, for example, I know that. And they open the room always in the law to say further financial services can be added by decision of so and so authority. So you will find financial services is always in a continuous development. And recently we saw, of course, the fintech is becoming, a revolution, and many jurisdictions worldwide. So they tell you that they have managed to handle the situation, but believe me, no one until now managed to handle what kind of financial services that will emerge out of a fintech. Anyway, let me start by telling you my statement about this matter, as that there is no doubt that arbitration has become the genuine, the original dispute resolution mechanism for commercial relations. And financial services is part of commercial services, but with a specific sector where this specific sector, as I mentioned, is continuously developing and subject to rules of law and regulations and announcements from supervisory authorities that also continuously changing. And that may raise a lot of disputes between stakeholders in that sector. Let's say, we have seen recently a lot of international arbitration avenues and centers have taken that into consideration, and they thought that they can play a role in helping the financial sector that is until now is hesitant to use arbitration as a suitable mechanism. Financial institutions, banks, and other financial service providers, they prefer litigation over arbitration, like our colleagues, your guests, have already mentioned that. Because as I referred to the supervisory authority's role, and there is a sovereignty kind of let's say laws that govern financial services. They prefer to have a decision from the courts where a court can grant them preliminary orders and needed quick decisions in relation to the transaction. However, they noticed that the continuous development of complex issues in financial services makes it too difficult to refer the matter to a judge who has little knowledge in this area. Because of the tremendous amount of cases of different types, you cannot expect from a judge to be so knowledgeable in different types of derivatives, let's say disputes or loan or commercial finance and trade finance in general, and many other examples. And Ms. Nargis already mentioned to you how they are expecting a great difficulty if any kind of law will govern fintech in the country, how the courts will be able to handle disputes arising from that sector. And this is an issue that I will approach it in more details now. The trend, as I mentioned, in international commercial relations and in banking sector and financial services has started to recognize that arbitration is a mechanism that is truly suitable also for financial services. The advantages that were mentioned by Mr. Igor are true, and you don't need my this statement, but it is true because the parties have the ability to have expedited procedures. There is a possibility for getting a summary dismissal procedures where you can bifurcate the procedures and decide on substantive issues relating to jurisdiction or arbitrability of the matter at the beginning of the procedures without going through a long process. Also, parties in arbitration can have let's say a better possibility for, and this has become facilitated. I mean, international financial arbitration centers and well-known arbitration centers started to draft more specific rules of arbitration for this particular sector. So they allowed the summary dismissal procedures, as I mentioned, for financial services in particular, and the ability to let the parties to allow them to join an ongoing procedures because and that this is very important for financial services because of the number of parties involved in the contract. So once two parties have the dispute, other parties in the same contract can join after the commencement of the procedures, and this is a very good advantage for financial services. In addition to that, of course, the confidentiality and privacy, which is an advantage we all know about arbitration, and in financial services, they need that. A lot of parties, particularly in financial markets, they prefer not to announce information or sensitive information relating to their financial transaction. More than that, I mean, in arbitration, you will find, especially in institutional arbitration, you will find case management ability, where that may limit the number of submissions, and parties even can agree in their arbitration clause or later after the arbitration has commenced to decide or to permit the arbitrators to decide their dispute based on documents only, without the need for hearings and sessions. So that adds speed and that adds accuracy to that kind of relationships. As Mr. Rebor also has highlighted, the importance of the choice of the seat of the arbitration. That's very important, and this is an issue for TIAC even to consider as a strategic option. I believe in this session we are requested to provide TIAC with some kind of advice and approaching and providing real studies for the future to become an institution for the entire region as a place and a suitable seat for resolving that type of disputes. The choice of seat requires, of course, good training of judges, because the arbitral award, when it is issued, or during the procedures, may be subject to some kind of challenges, and so the court should be involved in developing a suitable seat for financial services in Tashkent. In addition to that, of course, the availability of suitable qualified, and that is when I refer to our topic today, qualified arbitrators in the sector, qualified in financial services, and at the same time they have good experience in administrating justice, administrating the procedures in arbitration. Of course, they understand the process from the beginning until the end. I'm referring to arbitration. At the same time, they have the experience needed in that particular sector of the financial services, because as I mentioned from the beginning, financial services are so complex, they are so varied, and there is a wide area of business models and different transactions in financial services. So not only that you announce that I am an arbitrator specialized, and I am a good arbitrator, of course, trained in arbitration, and I can administrate procedures, but also you have to state which area exactly in the financial services you have the knowledge at, so the parties can select that arbitrator. One of the questions perhaps you have mentioned at the beginning is the meaning of financial services. I mean, this is a very difficult question, John, because as I mentioned, it's so there is a great variety of financial services, but national laws can lead you to the answer by reviewing the central bank's law and financial markets and the practice as well, because you may have, as I mentioned, derivatives, loans, guarantees, factoring law. You read from my CV or biography is that I have developed a factoring law. Let me state that today only, I have received a signed version of the law. So today, John, you know that you are in the UAE. We have a factoring law, independent, special for factoring. This is a great development.
Congratulations.
And he knows what I'm talking about, how important this is for the economy. It is based on the international model, so it is already integrating with the international practice. And that may also lead us to different types of disputes again. The creation of the agreement, the verification of the parties' rights, their legal relationships between the various players there, and of course the liability between the parties, liabilities towards third parties, and so on and so on, and even of course bankruptcy can be considered in these relationships. In addition to that, we're working on the finance leasing law. We already have a law, but we're working on a law that has, the international, let's say, approach. So our law should directly, once it is issued, and very soon, hopefully, will integrate to the international community in finance leasing. And that also brings in different types of disputes. And this is these are financial products, by the way. They are defined under the as financial services, in addition to lending, as I mentioned, in addition to many other issues. So the lessee, the lessor, third parties, all of the relationship, the liability, priority of the parties, everything plays a role. Also, the secure transaction law, the securing assets with movable assets or rights with movable assets is another law that has a relationship with the factoring and finance leasing in a way or another.
So,
Anyway,
along those lines, one of the things we're trying to get answers to, of course, you know, we're not going to solve the problem in 90 minutes, but it's the discussions are very fruitful. I guess what I'm wondering is, especially now, you know, as Nargis has indicated, and we all know that we see these financial products changing and evolving, and I guess what I'm wondering is it so complex and changing so fast that it's, you know, I guess what I'm wondering is what kind of background are you recommending that arbitrators get? You know, we all are not going to go out and get our CFA or CPA or become, you know, stockbrokers, but we do want to enhance our knowledge of accounting and finance generally. I get what I'm driving at is, do we need to have, if you have a 3-member panel, do you need at least 1 or 2 persons with significant experience, like a CFA certification of some sort, or is it good enough just to have general background? Because again, these things are changing so fast, it seems to me, and some of them are so complex, that you're going to need experts to address the tribunal anyhow. So isn't it good enough just to, in the same way as construction arbitration, for example, you may not be an expert in construction, but you have experience in construction, and then you have experience in arbitration. So, Mr. Smith, who has that experience, is a good choice for construction arbitration. How do you see that choice when it comes to financial services, given the complexity and given that they change so rapidly?
Yeah. John, thank you. I mean, I think, of course, when you have a panel of 3, yes, one of them should have that kind of particular experience in financial services. But the answer to that, and more accurate, is that will depend on the dispute and the subject of that dispute, of course, to determine whether you need, as I mentioned, the original or the dispute, if it relates originally to financial services, full stop. I mean, it's not a mix of commercial and finance. Then perhaps you need someone who has that kind of knowledge, at least the chairman of the tribunal in that sense. And you find, for example, the ISDA have already worked, perhaps Mr. Igor also mentioned that, but I should mention it again, that they're working on developing arbitration clause and arbitration and different versions of arbitration clause in their master agreements. And there are also a trend towards developing arbitration procedures in various arbitration centers. The Hong Kong, they have issued in 2011 financial dispute resolution peculiar to financial services kind of disputes. Also in China, the China International Economic and Trade Arbitration Commission, they have also enacted some kind of financial dispute arbitration rules. In various places, you will find arbitration institutions have started to focus, either established genuinely for financial services or establish a branch particular for financial services. That comes with a completing element, which to have a list of arbitrators who their qualification is in financial services and have already the good knowledge in arbitration, because you cannot have just only a financial services expert. You cannot administrate, the procedures, and you may end up with an arbitral award that is not enforceable, not in the domestic where the arbitration took place, or even on based on New York Convention if it is a foreign arbitral award, because he has to have that kind of knowledge, he or she, of course, that particular knowledge in arbitration. And the same for an arbitrator who's mastered the arbitration fully. And like yourself and myself have a lot of, let's say, articles written in arbitration and knowledge, but if you don't have the at least the basic structure of that particular area in the financial services, you will find a lot of obstacles, and you will need to use a lot of experts as appointed experts to the tribunal. At the end, that expert who would write the arbitral award, not you, and you will just only sign what he has written, but you need to have that ability to understand at least that report, okay, analyze it and say, yes, I agree, or I don't agree for particular reasons, or you will be able at least to, as an arbitral tribunal member, to cross-examine that expert at least,
Mm-hmm.
So I think there is the Prime Finance. This is an organization that managed to create a panel of recognized international market experts, and so there is a trend, you see,
Mm-hmm.
and it is developing. And let me just end up with conclude with relation to fintech, because as I mentioned, we have drafted national law. I mean, this is a trend. You don't find many countries have a national law to govern fintech. You will find various legal instruments issued by different authorities, but we have drafted a law, and it is in a stage when where we have referred it as Ministry of Finance to the Ministry of Justice. There is a committee there, and after that, I will discuss it with the cabinet. Then, another layer of experts. But the draft was written with the help of international law firms, and already consulted the central bank and the ISCA, which is the financial market here in the UAE, on its structure, and focuses was a lot on what we refer to as enabling technology. This is for Mr. Nergis, just to give her a few hints on this, legislative, perspective here. So disputes will arise, and I've noticed that WIPO has announced that they have developed for fintech, financial technology, some kind of dispute resolution mechanism. But what I found there is that it relates to, intellectual property, as the WIPO is specialized in that area. So the developers, whether they are fintechs or, the big data kind of companies, or that is with small companies developing fintech, as a technology or as algorithms in that area, may want to save their rights over it. But the financial as finance, the concepts will still be subject to the laws that govern that financial technology. If it is a group funding, or you develop Islamic banking based on a blockchain, then it will be subject to the law that governs Islamic banking, combinedly with the law of fintech, that just to see the effects of that technology on the market for several supervisory authorities, not only the central bank and ISCA traditionally, but you will have to create 2 or 3 other layers and facilitate the matter for entrepreneurs in this area. I should leave some room for others. Thank you so much.
Fantastic, Doctor. Thank you so much. Let's switch gears from the UAE and the federal ministry, legal consultancy, to another person on the ground, but this time in Uzbekistan. And this gentleman, his name is Mr. Erkin Turabov, and he is the head of the legal department of the largest commercial bank of Uzbekistan, JSC, National Bank of Foreign Economic Activity of the Republic of Uzbekistan. Mr. Torbov has broad experience in banking and finance, corporate and dispute resolution issues. He is a graduate from the National University of Uzbekistan and the University of Essex. I've talked to Mr. Torbov once before on this issue about a month ago, and I'm eager for him to share his thoughts, again, from an on-the-ground lawyer in Uzbekistan dealing with these issues day to day. Mr. Torbov, the floor is yours.
Thank you, Mr. John, for introduction. I welcome everyone, the panelists and the participants. My name is Erkin Durabov, and I am head of legal department. So I'm going to present some information about the current trends and current issues involving banks in dispute resolution in Uzbekistan. I hope everyone see my presentation. So just a second. Okay. Just a short overview. In Uzbekistan, there are 32 commercial banks operating in Uzbekistan. So commercial banks in Uzbekistan are the most active economic players. So because they're most active in economic, there are also a lot of dispute resolution cases involved with commercial banks. And the major subject for such kind of dispute resolution is a collection of debt of loans. Of course, there is also other disputes involving financial services. For example, we have disputes with initial public offering recently and other complex disputes, but in majority, commercial banks has issue, the major subject is collection of debts. So currently, commercial banks use three dispute resolution tools in Uzbekistan. So first of all is litigation in domestic state courts. Second is so-called notary performance letters, which issued by the public notary in Uzbekistan, and local arbitration institutions. So litigation in domestic state courts, it is the most frequently used method of debt collection nowadays by commercial banks. You know that we have some jurisdictional division between the courts. In most cases, disputes between companies are considered by the economic courts, as many in CIS countries also in the same situation, where the respondents are the individuals. The cases are considered by the civil courts. So the advantages of the litigation in domestic state courts in comparison with the local arbitration institution is there is no necessary for additional procedure to receiving enforcement order in case of we compares with local arbitration institutions. And another advantage, it is allow when the bank's debt collection, you can apply for the pledged property. It's allowed for the banks to sell the pledge in open market and sales. But there is a big drawback for the litigation in domestic state courts. It is a timing issue. The procedure is a big challenge. For example, an average taking into consideration pre-litigation procedures, it takes about 3 to 4 months to get the decision from the first instance. If some respondents try to make an appeal, it takes much longer. For example, 6 to 8 months. So the timing is a big issue and challenge in when you litigate in domestic state courts. The second option is a notary performance letter. So the law of public notary of Uzbekistan allows for the lenders to apply to notary public to receive so-called notary performance letter. It's a simplified procedure when the borrower agreed that he has a debt, the bank usually apply to receive such kind of letter. So in terms of timing, it can be obtained up so very fast, but there is a one drawbacks. It mostly used for the debt recovery from the individual based on consumer loans, because the notary performance letter with notary performance letter, you cannot apply for the pledge. So you can ask only debt, not the pledge. So the third option is a local arbitration institutions. Local arbitration institutions operating in accordance with the law of Republic of Uzbekistan on arbitration course, which is adopted in 2006. In terms of timing, it's better than domestic state courts, but as I said before, in terms of, and this is also the big, much broad discussion between arbitration and domestic litigation. The issue that if the bank go to the local arbitration, then it's required to make additional procedural steps. It's we need the banks need to receive
Hello, Erkin?
sorry,
We
I
lost
moved
for a
out.
second, yeah.
Yeah. So as I said, local arbitration institution required additional procedure. In terms of material grounds, I would say that there is what kind of issues that banks challenge in the courts is a dispute on invalidation of security agreements. Usually when the bank go to the debt collection, persons who provided the security try to invalidate the security agreements. This is a usual practice for them. So in this scenario, this leads to the suspension of the trial and the situation where the bank may lose collateral. So we have such experience also. So there is a room for the banks to look carefully the transaction documents, because the the grants for recognizing security agreements as a word is basically that, for example, there is no resolution of general meetings of shareholders for issuing credit product by the bank, breach of the rules of corporate rules of making material transactions and so forth. So another issues that banks challenge in the domestic courts is when the borrowers try to challenge the interest on the loan. And there is also issues with the lack of financial background in court judges in some cases. Every time when the borrower tries to challenge the interest on the loan, courts usually appoint the experts. Usually these experts come from Central Bank of Uzbekistan, which is a regulator of the all banks in Uzbekistan. And on the basis of the expert examination, then the judges will issue the decision on the interest. But this whole situation also leads to the suspension of the trial. So I think if the arbitrators or judges has a much more financial background, probably they might not need to involve some experts.
So, Mr. Arkin, do you think it would be useful to, for the judges, for example? I mean, of course, it seems that the trend is arbitration in terms of international, and it may be that you go that way locally eventually. But for the time being, if these matters are being determined by the courts in Uzbekistan, would it make sense to have some sort of training program in finance and basic accounting for the judges?
Sure, you're right, John, because what we see in the what we see in the courts in local arbitration institutions, we see that mostly we know that judges and arbitrators in Uzbekistan is lawyers, mostly lawyers, but usually these lawyers doesn't have any kind of financial background. They not work in the banks or financial companies. So in some issues they are not provide adequate attention. So I think that there is a room for development, and one of my proposals, as you see, I look for the local arbitration law, and one of the requirement of that law is that if there are any sole arbitrator appointment in the local arbitration, so it should be person with a higher legal education. So in case of panel appointment, the chairman of the arbitrator tribunal must have a higher legal education. So I think there is some rooms for the development. So such strict requirement for the sole arbitrator should be, I think, changed. So because it contradicts with the party autonomy to choose the arbitrator which one they want to resolve their dispute. Maybe they will choose someone from the financial background.
Yes, yeah, it clearly makes sense. And, you know, I'd like your point about persons, for example, someone in your legal department who has a legal background, maybe they don't know, he or she doesn't know arbitration so well, but they have a financial background. Then maybe one option would be for them to learn arbitration, you know, which takes a while, by the way. But you know, especially in order to be on tribunals and panels deciding complex legal questions, whether they're in the financial sphere or otherwise. But these are great points, and it's nice to get your perspective from, again, someone that practices on the ground. And I guess if you didn't have anything else, I would like to just ask you a question. What do you see the trend in Uzbekistan with respect to arbitration of financial services?
Well, general trend is that commercial players want to receive more affordable, more fast tool to resolve dispute resolutions in terms of financial services. And what we see now, what we have now, the domestic litigation and domestic courts are overloaded with a lot of cases. I saw the recent statistic that from the beginning of this year until now, the domestic courts resolved around 400,000 cases. So in most cases, domestic courts are overloaded with a lot of cases, so it's the attention the judge can move to the one dispute a little. So there should be room for the development of local arbitration, but again, still commercial local arbitration also developed in the past 10 years, but I think it's not enough developed. So I think the local arbitration institution must adopt new tools. For example, such kind of express arbitration. We see in the pandemic that a lot of international arbitration centers adopt such calls express arbitration tools. I saw the Stockholm International Arbitration Chamber adopts express arbitration. So maybe if the local arbitration institution adopts such kind of fast arbitration tools, so it brings more attention from the commercial bank, from the other economic players to move all their dispute resolutions and cases to the local arbitration institution rather than the state courts. So, John, I guess your microphone is out.
John, your mic's off.
Sorry about that. Well, thank you, Erkan, for that insight on the ground in Uzbekistan. One of the hallmarks of TIAC is timely starts and timely finishes. So I am mindful of time. And I would like to hear from our two remaining speakers. Professor Dr. Yui Wista, he's an expert, and Yui got his PhD in mathematics, mathematical finance with Stephen E. Shreve at Carnegie Mellon University. He is the author of 2 books, one Foreign Exchange Risk and FX Options and Structured Products. He writes a financial column for the Wilmot magazine and he has published many academic journals. Yui is professor of foreign exchange derivatives at the University of Antwerp and an honorary professor of quantitative finance at Frankfurt School of Finance and Management, lecturer at the National University of Singapore and Warwick Business School. His work in arbitration started in 2006, mostly as an expert and expert witness in litigation and arbitration at major financial disputes at the Commercial Court London, Vienna, New York, and the Singapore International Arbitration Center. He is certified public expert for currency and interest rates markets at Frankfurt's Chamber of Commerce and the UK Expert Witness Institute, as well as an honorary judge at the State Financial Court of Hessen in Germany. Ever since he started his FX options front office role at Citibank in 1992, he has been working in capital markets at UBS, Deutsche Bank, Oppenheim, Commerce Bank, as consultant to many major banks in Asia and Europe. Since 2003, he is the managing director of Math Finance in Frankfurt and Singapore, covering many capital markets disputes around the world, along with valuation, model validation, derivatives, and pricing services. So without further ado, Professor Dr. Yui, the floor is yours.
Thank you for the introduction, John, and thanks the committee for inviting me to join the panel. My name is UzAW. I'm a mathematician, and let me pick up on some of the points that I've heard during the discussion, which were all very interesting and insightful. I'll share some of my experience here, and I'm going to conclude with recommendations what could be and should be done in my opinion. Right. You heard I'm a judge, probably the first mathematician who made it to the court as a judge in the financial court in Germany. Why is that so? Because the world has become more complex and judges alone cannot really conclude on matters of high complexity. So I think we all agree on that. I started off in 2006 with a case on mediation, which was interesting because it was a very big media agency with a daily newspaper, International Loan, that teamed up with a rating agency to then blackmail a bank in Germany. And they were saying, okay, we'll write bad press about you and your products unless you give us a consulting mandate, right? So that highly interesting. So that's how I got in there, because I knew how to value the contracts under consideration. There were multi-stock with high correlation products with a series of coupons, even linked to the result of the World Cup. So highly complex. And I acted as a mediator, and they could settle actually within a few weeks. And that was really good, because the time factor was important, because every day counted in this matter. You wouldn't want to wait for a court or even for an arbitration to get on with the topic, right? So that was inspiring enough for me to start working in that area, mostly as an expert for risk management topics, for patents in financial software, for ISTA cases, done a lot of ISTA cases too, on interest rate calculation, on derivatives pricing. Let me give you another example. In London court, when in the beginning, Igor said it was good to have an arbitration tribunal, and in some cases, I have to say, you have to be lucky if you get a tribunal at all, because many of these cases are actually handled by a single person, a single judge, right? So the example I got involved in at the Commercial Court of London was an $8 billion claim, probably the largest currency derivatives claim ever in the world. So $8 billion were claimed, and the case was handled by a single judge. And the issue I found there was, we were talking in the courtroom for 40 days. I was one of the experts just to actually be called up last. And the matter was complex. It was structured products with lots of different fixing schedules and barriers and leverages and all kind of words that come in here that many ordinary people would have never heard of. And the question is, were all of these products actually options or not? And so the thing is that the judge called me in the last day, and the last question he asked in the case was, what is actually a strike? So for the benefit of everybody, this is a very simple question for somebody who knows options, but it clearly told everybody that the judge has no clue what's going on, right? So, and he still had to make up his mind about this $8 billion claim. Right, so that's the issues here. Time is another issue, extremely important. Done another example where I wrote an 80-page report, and then the prosecutor told me, well, it's very nice, your report is great, but we actually can't use it because the court is going to be busy for another 7 years until they can pick up your case. By that time, the verdict has probably died. So. And right now in Germany, and just to share with you, financial courts are all blocked because all the judges have been called to handle diesel scandal matters, right? So nobody's working anymore. Fantastic. So we need arbitration very, very desperately. My conclusion is, on the arbitration, we need a tribunal. A single person cannot handle that level of complexity and maybe even biased or maybe considered to be biased. So we definitely need a tribunal. In my opinion, there should at least be one, if not two, on the tribunal with financial background of general level, which could be a CFA or also relevant work experience or a university degree or some other trading certificate. Plus, because the tribunal members are typically lawyers, you cannot expect them to know everything, right? And nobody can be an expert in everything. So that's too much to ask for, but there should be a possibility to add on a subject matter expert to the case who can advise the tribunal if on demand if the tribunal isn't able to handle it themselves. Now, how can that be organized? How can it be done? I think what's done very well in Germany is organizing experts at the Chamber of Commerce as publicly sworn in and registered experts. They train their people very well. I've done the exam, and I can tell you it was harder to pass this Chamber of Commerce exam than to do a PhD, which is really strange. Being a graduate from Carnegie Mellon, done my PhD in everything, right? Then I go to Chamber of Commerce, which is done for like butchers and people like that. And I've done the exam on interest rate calculations and derivatives valuation. But that's good because then you have this list of experts with their fields, right? Everybody knows that they're trained and that they're regularly examined every 2 years. They have to show that they're active and current in their knowledge. And then you have a database. If you have something, some topic of interest, you can scroll down the database and put in your query and say, okay, here are 5 experts of whatever you need. You call them, and then it would be very easy to come up with a reasonable judgment if people are educated. And that is the way it can be organized, right? So I'm not seeing that in many countries. That's something I have to say, this model that we have in Germany could serve as a role model.
Very insightful. Yes, indeed. Yeah, I like that. We'll have to think more about that. That makes eminent sense. Of course, it's a different thesis. You know, one of the theses that seems to have some sort of consensus among our group today is that yes, the arbitrators themselves need to learn about this stuff, to learn financial services. And, you know, as I asked Dr. Talhouni, what is the balance here, right? You can, and as you mentioned, Professor, you can't know everything, no matter how smart you are, no matter how much you know about a particular area of finance even. You're not going to be, you may know stock options, but you might not know the currency markets, you know, and so what you're saying may be indeed part of the solution, but I gotta believe that it would help both aspiring arbitrators and existing arbitrators if this is an area that they want to dive into. And it seems like it's here to stay, and it's complicated, and it's a way to practice our respective crafts, if you will. You know, what is it that we need to learn, or you know, do you take a course, get certified, and in addition, just have a panel of experts? And then the question becomes, does the panel itself have its own expert plus the 2 litigants, for example? So then you have 3 experts. And I know, Professor, you've been in that boat before when you have three experts, right? Which could spawn more confusion, possibly. No, likely.
Yeah, absolutely. You can't have 3 cooks, right? So
Yeah.
for a meal.
Yeah.
But we need people on the tribunal who can process the information that they get from the expert, right? If that education level doesn't have a certain minimum standard, they don't understand what the expert's saying. Right? So some minimum degree of financial knowledge would be highly advisable. or that field, in any field, right? Litigation and construction, same thing, right? That's some basic experience in construction would be important. Otherwise, how will you take a decision if you don't know this market? Right?
Exactly. And that may be something. It may be, for example, you know, again, you don't want an arbitrator or need one that has his CFA or his PhD in mathematics. Not that those two are equivalent, but the point being, you know, there may be something in the, you know, maybe a few rungs below that still gives you the working knowledge that will make the banks and others feel more comfortable when they choose their arbitrators. So, Professor, thank you for that, and we're taking notes and from you and our other speakers as well, and we'll try to come up with some recommendations for TIAC based on this. And we're almost out of time. Actually, we are, but I'm going to give 5 minutes, and I apologize for going over. That's a no-no under TIAC protocol. So I apologize for that. But I do want to engineer and friend Jamal Chehouni, and forgive me because I'm leaving you with 5 minutes, but I know you'll forgive me. Could you just, having digested all of these wonderful insights, and I know you've been around, you've traveled a lot, you know arbitration inside and out, you know probably more than anybody the different centers around the world. You're a member of many of them. Sorry, I don't have your CV in front of me at the moment, but can you tell me what your advice would be and advise the group and the people tuning in, both aspiring and existing arbitrators, what you've learned today and what you think what you think aspiring arbitrators and existing arbitrators should do to enhance their financial knowledge.
Yeah, well, thank you very much for this wonderful panel. I think Dr. Chehouni and Professor Wu have proceeded to explain all the good aspects. I can add no more except that in arbitration or any ADR, you need to go to the expert in that field. I wrote a book on how post-ADR, post-crisis ADR would be. So it's all about how technical should go into legal and how legal
Hello, Jamal.
Hello. Sorry, I think the laptop power is gone. Can you hear me?
Yes, we can.
Yeah,
Well,
I think the power is gone.
Yeah. Can you wrap up in 3 minutes, Jamal? Yeah.
So all I have to say that the best way for having a good arbitration and ADR is to go to the professional. In financial world, you have to go to the finance team, and in construction, you have to keep up good, at least having one in the panel to know construction, and you have to get the one that is really suitable for that particular project. So always please find the right skills, the right talent, and the right knowledge, so they can really add value to the ADR world. Don't go for the superficial and the very generic resume or profile. Go for the technical. That's what I have to say in this 5 minutes. And thank you very much all.
Great.
Sorry, now I'm using my phone. I don't do that usually, but that was a backup for the laptop.
Thanks a lot, Jamal. I appreciate you being the good sport. I know we cut you short. But anyway, I just want to end by saying great panel. Thanks for all the thoughts. Thank you, Igor. Thank you, Nargis. Thank you, Dr.
Thank you.
Thank you, Erkin, Torabov. Thank you, Professor Yui. And many thanks also to the TX Secretariat, who've done an amazing job.
Thank you, TX.
Under the leadership of Diana Bizakova, the director. You've been amazing. Keep up the good work. And looking forward to the next session. And sorry, we ran over a little bit, but
Yeah.
and we'll have more questions next time. Thank you, everybody.
Thank you. Goodbye.
Thank you all. Bye-bye.